will, our imagination, and being able to prepare for all the eventualities that might happen in this life so that we can be with you in the next life for eternity. We especially give you thanks for the guest speakers that we have here today, and I ask that you send your Spirit down upon all of us, that we may hear their words and take into consideration and let it affect us deeply how to prepare for illnesses in this life, how to prepare for our loved ones when we are sick and when we pass, and that we can make the best, most informed, and most loving decisions with regards to end of life. We ask this through Christ our Lord. In the name of the Father, and of the Son, and of the Holy Spirit, amen.
I'm Steve Warg from the Respect Life Ministry here at St. Chris. Just want to welcome everybody for coming. This presentation is being live streamed also. And for those who might be listening and live streaming, we'll try to answer your questions or keep you in touch. Elena, the woman doing the live streaming, will put up a slide with my name and cell phone number so you can text me a number, text me your question to my cell phone, and I'll be able to ask the question for those who aren't physically here. And again, I want to thank everybody for coming. I want to thank Margie, Mary Gutman, and Jonathan, the lawyer, who's here to give this presentation. I want to thank Elena Pope, our communications director, who's taking care of the setting of this all up. And I want to thank the Catholic Daughters of America, who are providing some slides and water after this presentation. I think, I'm not sure, we're having a little technical difficulties, but I think we can hear things okay. So, Margie, I guess I'll let you start over again. Okay.
So good afternoon. My name's Margie Christie. I'm the executive director with Dayton Right to Life. And the program that you're watching today came out of what we had saw probably 5 or 6 years ago with Dayton Right to Life, as we saw this push towards assisted suicide and euthanasia and all other kinds of things. And so we thought we needed to do a little better education on end of life. We know from Dayton Right to Life's perspective, of course, it's from the womb to the tomb. And so we do a really good job on the abortion and the beginning of life and life at conception, but we need to delve more into end of life. So this presentation came out of that whole situation. And so behind me, I gathered 2 experts in their fields, and we'll talk with them a little bit later, but it's a panel discussion. So we have a short video that starts us off from the New York Catholic Conference of Bishops. I don't think you're going to be able to see the video for whatever reason, but you'll be able to hear it. And then I will start the slideshow. Then Mary's going to talk about the medicinal, the nurse's point of view of all this situation. And then Jonathan, of course, is going to handle the legal questions. He's our attorney here today. So with that, I'm going to start with the short video. Again, I apologize if you can't see it, but take a listen. It's only about 8 minutes, and it does a great job of setting the stage for our topic. So here we go.
intensity of nursing, which provides the comfort for the patient. It's begun when a patient is in a situation where there's no more treatment, aggressive treatment that can be provided, that is going to be helpful to that patient. We're supporting them physically as much as we possibly can. And when they start receiving excellent physical care, then they are comforted by that. Some of their anxieties are diminished because they're not so worried about, are they just going to be pushed aside and not be cared for properly?
Euthanasia is in many ways a movement to promote acts in hospitals that actually take the life of an innocent patient.
If you examine the situations and understand the dynamics of what's happening, it's usually patients that feel as if they're going to be a burden. I think that's the essence of it, that no one is really going to want to take care of me, that I don't have value anymore. I can't do anything more for anyone else. So yes, let's just be euthanized. Let's accept mercy killing.
We are made in the image and likeness of God. Dignity is not in the way we live or die. Dignity is in what we are. Now, it's really important to emphasize that as Catholics, we're not judging the quality of the life of the patient. But what we can do, in a sense, is we can judge the quality of a particular medical intervention. For the most part, most often, the benefit of giving someone food and water always outweighs the burdens, because the benefits of keeping that patient alive are so great that they outweigh the inconvenience of having someone, in a sense, be dependent on us for their food and water.
You have to relieve the symptom. There is no question that with attention, with affection, you can prevent patients from saying, I want to die.
The alleviation of pain is something that every Christian should try to seek out, because to alleviate the suffering of another is an act that falls under the commandment to love one's neighbor and oneself.
The physical aspects of suffering are the easiest to control. The hard part is the emotional suffering.
The most important thing that one can do to prepare for the medical contingencies that arise at the end of life is to appoint a medical proxy. And this is someone who will be able to speak on the patient's behalf when the patient is unable to speak for himself. Now, ideally, this is someone the patient trusts. This is someone the patient has spoken about the end-of-life issues that could arise. This is someone who is prudent. This is someone who is faithful. This is someone who is somewhat cognizant, who is able to understand the Catholic Church's teachings about what is morally permissible and what is morally impermissible at the end of life. This is a time for us to look forward, to look is an entry into eternal life.
I apologize again, you couldn't see the video. They did a good job of pulling in different resources. One was a doctor, one was a religious nun, a brother, I think, was on there as well. So, but again, I think you kind of got the feel for why we're here today. And so I'm going to start with that a little bit. Now don't tell me the clicker's not going to work either. Okay. Is it moving? Did it move? try to use the microphone here. So we're here because we need to have the conversations, the end of life, the difficult conversations, before we're in the throes of an emergency room or a nursing home or any other type of situation. That's not the time to be making decisions of any type of seriousness that's involved here. So what we encourage folks is to have these discussions now. Start thinking about these things now. And actually, as part of our catechism in the Catholic Church, the Church tells us that we're encouraged to prepare ourselves for the hour of our death, as we hear in the Hail Mary. We're encouraged to prepare spiritually. Are we in a state of being able to pass without mortal sin? Are we physically prepared, mentally prepared? Is our family prepared? We're called to be prepared as part of our faith as well, and just practical reasons. And so how do we start that whole process? How do we begin to feel prepared? And I guess we need to think about it. And no one, of course, wants to think about their own mortality, but we do need to think about that a little bit. And maybe how we've experienced death with our family and friends. My mother passed away in an emergency room, very unexpected. My father passed away at home. We were able to take care of him. And then my brother passed away after a prolonged illness at 60. So I've kind of seen death all different ways. None of them are pleasant. And every one of you have probably experienced death in your family, and no two deaths are ever the same. So there's no way to have like a master plan, but you have to personalize it towards your experiences with your family and friends. Look at your faith life. Maybe that helps you deal with, what you want to think about. What things do I want to happen? What things do I want to have in place? What relationships do I want to be healed? All those kind of things that we need to think about. And then, of course, you just want to clear up any misunderstandings or misconceptions about medical procedures. My brother passed away at age 60 of esophageal cancer. And because the chemo and the radiation were so rough on his esophagus, we had to put in a feeding tube. And if you would have asked him at, 25, 30, 40 years old, oh no, I don't want to be on a feeding tube, I don't want to be on a feeding tube. Well, that feeding tube gave him several more months of life that he could do things that he wanted to do. He was able to ride his bike with his feeding tube, much to my sister and I's chagrin. But we're like, are you sure you're going to do that, Dan? Yeah, I'm going to ride my bike. All right, pal. So it just because you might have a misconception about something, now's the time to be thinking about that. Maybe a feeding tube isn't what you think it is, or being on an intubated isn't what you think it is. We, of course, all know a lot more about intubation now after COVID. And Mary can explain this much better than me, but sometimes your lungs just need a break. And you need to be on the ventilator, let them get some rest, and then you can come off. So, again, all that starts there. And then, of course, conversations with your family. That's important. Let them know what your fears are, maybe what their fears are. I think one of the saddest calls I ever got in the office was we did this seminar up at St. Mary's area, Russia area, and I got a call the next day from this woman, and she was probably in her early 90s, and she says, I keep trying to talk to my family, and they kept saying, no, Grandma, you're going to live forever. No, Grandma, you're going to live forever. We don't want to talk about it. You'll be fine. It's all good. We need to start preparing our family as well. As much as they don't want to hear it or think about it, it's all a reality. And so, again, talk with your family. Probably Thanksgiving dinner is not the place for having that conversation, so you have to be a little savvy and pick your time and place. But again, talk about your faith, talk what they are feeling and their fears as well as yours. In your packet, and I didn't do a very good job, I should have started with this. In your packet, on the left-hand side of your packet, is what I call Jonathan's side of the packet. So all of Jonathan's stuff will be on your left-hand side, but on the right-hand side are all the resources, questions, Mary's information, my information, all kinds of good things. And there's a little question sheet in there maybe to kind of get you thinking and talking, and take it to prayer. take some time and pray about it. And again, talk with your family and friends. And we'll go over a lot more of that a little bit. So I'm going to turn the seminar, over to Mary Gutman. Mary Gutman, can I tell him 50 years as a nurse? You prefer not? I tell. So too late, already did. And there's her information and her background on there. But I'm going to turn it over to Mary now, and I'll be your slide clicker.
Oh, will you be? Okay.
I will be.
Okay.
So let me know when you want to.
Can I? I'm going to move this
Yep.
over here, please, if you don't mind. Okay, it is true. I have, I graduated, I'm a registered nurse, and I graduated from nursing school well over 50 years ago now, and practiced at the bedside and in nursing administration for about 20 years or so, and then I switched gears and went into what is called healthcare risk management, which is patient safety, but also insurance placement, property, that kind of insurance, medical malpractice, et cetera, and a lot of regulatory things. But today, because we've done this here before, I'm going to focus a little bit on Catholic teaching, but also, before I go into that, I want to just kind of give you a background about how things came to be in this country and certainly in the world. When I was a freshman in nursing school, if somebody died, they died. There was no cardiopulmonary resuscitation. Not 3 years later, we were doing CPR. We called what we called codes, or you might be familiar with that. The first coronary care unit in the United States was opened in Philadelphia in 1964. But within just a very few years of that, almost every major health facility had some form of critical care. So when I graduated from nursing school, the closest I got to critical care was working in a burn unit. But not 3 years later, I was working in a coronary care unit, and then intensive care, post-open heart, surgical, ICU. So how did that all happen? Well, it really was a lot to do with war. If you look at the things that happened during World War I, there were a lot of medical advances, but not as many as during World War II, and then you started getting the antibiotics, the penicillins, that kind of thing. During the Vietnam War is when things just spiraled fast, because those medics were taking young men out of the jungle, keeping them alive until they could triage them and get them some more emergency care. And all of that technology transferred into our healthcare systems. And it's pretty amazing. So in the 60s and the early 70s, you didn't have to talk about this stuff like withdrawal of treatment or withdrawal from a ventilator or any of that. Not even 10 years, within the first 10 years of my nursing practice, we started to have ethics committees. I served on one of our hospital's ethics committee for over 15 years and consulted on another one of our hospital's ethics committee. The whole issue of moral theology things came up that had to be discussed. So if you think about it, I was just yesterday looking at Harvard came out with a list of medical advancements from the last, I don't know how many years, 75 to 100 years. It was real slow for a while. It was like every 10 years something big would happen. And then all of a sudden, Vietnam era, it was every year 2, 3, 4 things. We were doing transplants in Dayton, kidney transplants in Dayton at Miami Valley Hospital, I think in the 60s, in the late 60s. But before then, if you had end-of-life issues, you died. And there was nothing that you could do about it. My own father died at age 35 in 1951 of renal disease caused by high blood pressure. The year after he died, the drug Reserpine came out, and they were able to control blood pressure. If he had had advantages of that drug, who knows if he would have been able to live longer. But his kidney failed because, both of his kidneys failed because the pressure in the kidneys was too high from his high blood pressure. So I think about that stuff all the time, and I think that it puts this, what we're talking about, in perspective. You could probably take that. Okay. All right. Now, I'd like to talk a little bit about, we're going to talk about nutrition and hydration primarily, and then we can back in when we get to some questions on other things. I would venture to say that most of you come here with a family member, yourself, somebody dear to you that is facing some issues, and that is what's prompting you to find, what about this, what about that? That's great. That's not great that there are issues, but it's great that you're here to talk about this. The church, before we talk about nutrition and hydration, let's talk about ordinary treatment. Ordinary treatment is that treatment that we're obligated to provide and to accept as ordinary means of sustaining life. These treatments offer reasonable hope of benefit without excessive burden. An example of ordinary treatment is nutrition, hydration, and certain medical care. And this teaching is based upon natural law and the fifth commandment of the 10 Commandments. Let me give you an example. Let's pretend that I was diagnosed today as a very brittle, which means you're diabetic. You're up and down with blood sugars. And my doctor said to me, Mary, I'm going to put you on some insulin. I cannot refuse to take insulin because, gee whiz, I just don't want to take insulin, because that is ordinary treatment for the treatment of diabetes. So that's one example. There are millions of examples that you can put out there. But it is something that when decisions are made on these issues, you have to consider what ordinary treatment is. So extraordinary treatment is a term we use that says when the benefits do not correspond to the burdens of treatment and the treatments are out of proportion to the expected benefit. That's probably the same way of saying that twice. And you heard that a little bit on that film. An example of that might be, and this is, again, nothing, they said it and I'm going to say it again, nothing is black and white here. And everybody that asks these questions wants, well, is it or isn't it? Are you hedging? No, I'm not hedging, but everything is, there's a little bit of room for wiggle sometimes. But here's an example. Let's say I'm diagnosed with ovarian cancer, and my doctor prescribes I'm going to have the tumor removed, I'm going to go on a round of chemo, and then I start to go into remission, and I go on another round of chemo, and I'm doing pretty good, and then 4 or 5 years later, I'm out of remission, and I have metastatic disease to my liver, my bones, the cancer has spread. For me to say I don't want to take any more chemo, that could be considered extraordinary for me. That doesn't mean I want to die tomorrow, but on the other hand, the burden of that chemo, the fact that it isn't really going to cure my disease, could be considered extraordinary treatment. Does that kind of make sense? You take every situation and you weigh it. And you need to have the input of your treating physician. You need to know the risks and the benefits of the treatment that's being proposed. And I know so many people who say, well, yeah, he told me, but I don't know if he told me that. Well, I don't want to ask him. I don't want to bother him or her, your doctor. Bother him. You need to be able to make informed decisions. And you can't do that if you don't know what's going on. So, okay. Next. I'm going right to nutrition and hydration because this is the fun one. Because, talk about black and white. In general, and this is the teaching of the church, food and water are a natural means of sustaining life and are not considered even medical acts. So in general, that's church teaching. They are considered ordinary care and obligatory to provide. However, it could be excessively burdensome when the person is dying and cannot assimilate or absorb the food or the water that is being given to them. This issue was addressed in 2004 by St. John Paul II, and this is a typo, reaffirmed by Pope Benedict XVI. There's supposed to be a Roman numeral 10 there. And when patients are imminently dying, often they can't absorb. Your body starts to shut down. So I use this example all the time, and I never knew my Aunt Agnes. My Aunt Agnes died when she was 21 years old, and this was probably in 1936 or so. She had cancer, but they didn't know what cancer was in 1936. So she lived in a big city, and they sent her home to my grandparents on the farm to die. And my mom had just graduated from high school, and this was her big sister. And so my grandparents said to my mom, whose name was Elaine, Elaine, you stay home, don't go, we don't want you to go, she wanted to be a nurse in the worst way. We don't want you to go to be a nurse, we want you to stay home and help us take care of Aggie. And so she did. And she always would tell me, you know, there was a point where Agnes couldn't swallow. So what we would do is we would take a washcloth and put some water on the washcloth and put it between her lips, and she would get enough moisture to be comfortable. But we couldn't feed her. And this, now, in the 30s, they didn't have all kinds of tubes that they used. So that wasn't even an option. But that always struck with me. And I have seen many, many people die. I've been with many people when they've died. And honestly, and especially hospice people would tell you this for sure, that your body, that's just a normal part of dying when you can't take fluids or nutrition anymore. So when St. John Paul came out with this in 2004, do you remember Terry Schiavo? Any of you know that name? That was all going on, the Terry Schiavo situation. And she was the lady who was, for some reason, she collapsed, and she was in like a coma, and then she was in like what they called a permanently unconscious or vegetative state. And she was married, and initially her husband was solicitous, and then this went on for years, and she was in a nursing home, and her parents wanted to seek guardianship, but he didn't want to give them guardianship. It was this whole big hoo-hoo, and it went to the courts. Anyway, Pope John Paul was also suffering from his end-stage disease that he had. I think he had Parkinson's with complications of. So he came out and said very affirmatively that food and water are not considered extraordinary means of, did I say that right? Extraordinary means of care. However, there's a little thing here that I want to just read to you. This is out of a book, Life Issues, Medical Choices by Janet Smith and Christopher Kasor. This is exactly what he said. He said, I should like particularly to underline how the administration of water and food, even when provided by artificial means, always represents a natural means of preserving life, not a medical act. Its use, furthermore, should be considered in principle ordinary and proportionate care, and as such, morally obligatory. Insofar, and this is the kicker, as and until it is seen to have attained its proper finality, which in the present case consists of providing nourishment to the patient and alleviation to his suffering. The phrase insofar as and until it is seen to have attained proper finality is important because the Pope was not claiming that food and water must be given in all circumstances whatsoever if a patient cannot assimilate it. So assimilating and absorbing food, and nurses here would realize, if you're giving somebody a tube feeding, either through a nasogastric tube or what we call a PEG tube that's put in the stomach surgically, you can tell when it's not being absorbed because you can't get it in. It goes in a little bit and then it starts backing up. So I don't hope that doesn't offend anybody, but that's truthfully what happens. So that is why this is not a black and white issue, but you have to weigh the proportion. Is this person going to recover? Is this person going to recover enough to be able to be rehabbed? And you have to keep asking these questions. But if this person is eventually going to die imminently and cannot take the nutrition or the hydration, then it isn't withdrawing, morally withdrawing. Does that make sense? Probably not. But I think it's a big, when we used to get cases for medical ethics committee, what would happen on a medical ethics committee, you'd have physicians, a couple of nurses, a medical ethicist. We had one from the University of Dayton. You would have, we never really had lawyers. For a couple of reasons, but anyway, there were maybe about 10 people there, and either a doctor or a family or another provider would come in and talk to us about a case, and they would ask us to deliberate the case, but we never made the decision for that situation. Oh, okay. All right. Is there something important on there? I'm so smooth here. But anyway, in medical ethics committees cases, we would use all means to discuss the case, and then we would go back to that provider or that family and share with them our deliberation. But the decision was never ours to make. In other words, we didn't say, yes, you have to stop treatment, or we never did that. But again, up until probably the late 60s, early 70s, we didn't have to do that because there were no decisions like this to make. And all of a sudden, they became decisions. So I just have to say that there is not one answer that addresses these complicated issues. And we can talk about, you can ask questions later about ventilators. I will tell you, they always say pull the plug. That offends me like something, it's like spitting at me. We never pull a plug out of the wall and say, well, bingo, that's it. We've never done that. It's usually gradual weaning if someone's going to be removed from a ventilator because the ventilator is not doing any good. So there's all kinds of, this just goes on and on and on, but I wanted to give you that background about why John Paul said what he did, which is, I believe, very important to understand what was going on in the world at the time he said it. But he wasn't wrong. We do not withdraw ordinary treatment or ordinary natural act of eating or swallowing. Oh, I know. Can I just, one more thing. You know me. I get so absorbed in this, and then okay. Here, I had a slide somewhere that said, here are some medical issues related to nutrition and hydration, and these are just some of the situations that could be. Stroke patients who are unable to swallow. If you or a family member has ever had a stroke, you will know that one of the very first things that's done is the occupational therapist will come and do a swallow study to see if you can get if liquids go into your stomach. Because you don't want liquids going into your lungs or you're going to get pneumonia. And that pneumonia is going to be very complicated to treat. Patients with cancers of the GI tract, patients on artificial ventilation can't swallow. Patients who are ready for discharge to skilled settings, nursing settings, but have swallowing difficulties. And most skilled nursing homes will not take you with a tube that's in your nose because that they can put food down because of fear of what we call aspiration or getting fluid in your lungs. See, these are all things that come up fairly frequently. And then the psychiatric issue of people who refuse to eat or are vomiting, bulimia, that type of thing. And are really, many people in that situation are very near death because they've starved themselves to death. So those are just some situations. There's many, many, many more that these things can occur, that this becomes an issue. So with that, I'll stop. Think of questions. No.
You have a card in your packet, an index card in your packet, if you would like to write down a question. I'll collect those at the end and divvy them up between Mary and Jonathan. And so again, it all comes down to conversations with your doctor. And keep in mind, hospitals, if you've been to a hospital lately, you're not going to see your doctor at the hospital. You're going to see who's ever on call. Doctors don't turn to the hospitals anymore. So you need to have conversations with your doctor you go to so you can get a better feel for that. And keep in mind, sometimes they use the same language as we do, but they don't mean the same things. For example, medical care versus medical treatment. Those are two very different things in your mind and in the doctor's mind. So when you're asking things, is this medical care or is this medical treatment? To make sure, and again, risks and benefits, how's it going to affect my quality of life, all these kinds of things. These should be on one of the handouts in your packet. And then we've also included a hospice sheet in there, questions to ask hospice. Not all hospices are created the same. Keep that in mind. There are nonprofit hospices, there are for-profit hospices, in-home, at a place, and they all have different rules. Will you do CPR? My husband's in hospice, probably not. But I mean, all these different questions you need to ask your hospice provider. So that's in your package as well. I encourage you to look at that. Jonathan, you're up. This is, all I have is all like your goodies on here. Your UD flyer, law school, all these good things about it. Youth service award for attorneys under 40. Are you going to?
That was years ago. It was at one time.
So this is your slide, what they are and what they aren't.
Okay, well, that's fine, because I usually spend most of my time talking and hopefully finding something interesting for you. So my name's John Faulkner. I am a lawyer here in the Dayton, Ohio area. I have an office over in Inglewood and one in Beaver Creek. I spend most of my practice doing what's called estate planning. So in estate planning, there's lots of important documents. Many of them have to do with what happens to your things. That is not what we're going to talk about today. So things like a will, a last will and testament, a trust, a financial power of attorney. Those are all very important documents, very useful documents. That's a topic for another day, not today's discussion. Today's discussion is going to be on some very important documents related to healthcare decision making, which is in your packet, your folder, the standard State of Ohio healthcare documents. Those documents, there should be, let me look here real quick, sir. Yep, there's a form that looks like it's got a pyramid on it, and then there's some with some black lines at the bottom that look a lot like this, the big black stripe at the bottom. That's the actual healthcare directives. So the pyramid page is something that I have made up with references to Ohio law, and it's helping explain how the pages with the black lines on the bottom interact together. The pyramid page doesn't go with the black line pages. It's more of an explanation. So why don't we jump into those? And I want to kind of tie in the video to some comments that Mary said. The takeaway from today should be to have some thoughts going in your mind, to discuss those with decision makers, and to understand, like the video said, some of the best advice is to identify what some states call a surrogate or a proxy. Ohio calls an agent, but a spokesperson who can advocate for you with your thought and your conversation informing someone, and then taking the step of legally identifying a proxy, an agent, a surrogate. You are doing something very simple but very important, and that is recognizing that these decisions, healthcare decisions, maybe even end-of-life decisions, are complicated, and they have many, many moving parts. In my opinion, having done this tens of thousands of times with clients, having worked through the death and dying process with clients and family members, having recently gone through this healthcare decision-making process in regard to my own mother who passed away this summer, I feel very, very strongly about the need to have decisions from an educated baker, not a more strict cookbook. So what I mean by that is making checklists and making your own decision trees, and if this, do this. If I have this disease, then I want you to do these medical treatments or medical interventions. I think that's a large mistake. I think it's a large mistake because technology changes, your ability to heal from intervention changes. I think Mary gave a good example of going through a cancer treatment the first time might have a great deal of or high level of success. Going through that same treatment the 27th time may not be as effective. Why is that important? Well, it's hard to reduce these heavy, big decisions to just a checklist. It's not just writing a more detailed recipe. Instead, a better idea is to have a more educated cook. And that's where these documents come from. These documents that are commonly used in the state of Ohio and in most states really come down to two major healthcare directives. One is called a healthcare power of attorney. The other is called a living will declaration. They are both linked to healthcare, but they are doing two very different things. We're going to talk about living will first because it actually gets used in the fewest number of situations. So a living will is a declaration, a statement made by the person who has signed it. The person who has signed it is called the declarant. You are declaring decisions that you are making for yourself. In that living will declaration, you are identifying contact people who you would want a medical provider to contact if one of two triggering events have occurred. And those two triggering events are what leads to the interaction with the living will document. Those two events are either a terminal illness or a permanent unconscious state. Now, we could spend all week trying to define those terms. We don't have to define those terms ourselves because they are actually defined in the document. In the living will, it defines a permanent unconscious state as an irreversible condition in which the patient is permanently unaware of themselves or their surroundings. At least two physicians have examined the patient and agree that the patient has totally lost higher brain function and is unable to suffer or feel pain. It's bad, okay? If you have a permanent unconscious state, that's not good. Yeah, there's a medical term for that. It's starts with an S, I think it ends with an L, but it's not good. And in that condition, permanent unconscious state, it's a trigger for the living will to take effect. And it's basically the patient stating in that living will what they want the goal of their treatment to be. And really, there's only two main goals for treatment. One is to cure the condition, and the other is to keep you comfortable. Sometimes both of those goals can be accomplished at the same time. Sometimes only one can be accomplished. If that's the case and a person's in a permanently unconscious state, the standard Ohio living will wants comfort care to be the highest goal, keeping a person comfortable. So like they couldn't see what the man looked like, but there's a man in the video. He's both a medical doctor and he's a priest. And he talks about it is a good and Christian goal to reduce another person's pain. Comfort care is doing that. And the living will is saying that's what you want to be the highest goal if you are in a permanently unconscious state. The other condition when a terminal or a living will becomes the most effective document is a terminal condition, and that's an irreversible, incurable, and untreatable condition caused by disease, illness, or injury from which, to a reasonable degree of medical certainty, there's some more legal words, but at least 2 physicians, the attending and one other, have examined the person, and both of the following apply. There can be no recovery, and death is likely to occur within a relatively short time if life-sustaining treatment is not administered. So in both of those conditions, permanent unconscious state and terminal condition, it's bad, okay? So a living will is only having any kind of role in a person's medical decision-making at the end of life. If you are unsure of what you want the goal of your treatment to be, cure or comfort care, understand you don't have to sign a living will. Statistically, it's used in about 5% or less of cases. So it's not the most important document that you could have for yourself. Instead, the other document is used in a high percentage of cases, which is called the Ohio Healthcare Power of Attorney, or a durable healthcare power of attorney. Means the same thing. Healthcare power of attorney, what is it? Well, that's naming a decision maker. It's not you saying what you want the goal of your treatment to be. It could be cure, it could be comfort care, it could be both. What a healthcare power of attorney is doing is naming a spokesperson who can stand in your shoes and speak for you, give information about you, receive information about you, and make decisions in regard to your health, to advocate in collaboration with a medical provider, so that if you are unable to speak or advocate for yourself, this document is the linkage, the connective tissue, the permission slip that allows somebody else to speak for you. Folks, that is hugely important. I cannot emphasize this enough. If you don't have a healthcare power of attorney, I don't want to say this in a crass way, you're taking a large risk by not having a healthcare power of attorney. I'll be so bold to say you're a fool. Because if a person doesn't have a healthcare power of attorney, here's the legal reality. You're on an island, and only you can speak for you. And if you are unable to speak for yourself, the legal process that will identify the next spokesperson is called a guardianship. A guardianship involves a probate judge in Ohio. It involves a court hearing. It involves a whole bunch of paperwork that has to be served on you by a sheriff's deputy. And then it involves usually a lot of waiting. And if you're really lucky, it's going to involve lawyers and legal fees. I don't really like lawyers. I really don't like going to court. And the legal fee part, nobody likes. So, guardianship is the alternative to this. This is the easy way. This is you picking your spokesperson. Matter of fact, you can pick multiple levels of spokesperson. A primary person, if they can't, then a backup, and if primary and backup can't, then a next backup. You can name as many as you want. If you name them in a document, they could live anywhere in the world. If you're waiting on a guardianship, there are many states, Ohio used to be one of them, but there are many states that says your guardian that would be appointed by a court has to be a resident of this state. So if your most trusted person lived in Seattle, Washington, there are many states, unless they're in Washington, that would categorically eliminate that option, even if you wanted them. Fill out the document, they can live anywhere. See how that's useful? Plus, you've picked the order, not a court. So the benefit of a healthcare power of attorney is this. You've picked the spokesperson, you've picked backup spokespeople, you have stated for yourself that you are still in charge. It says it right in the second paragraph. It only takes effect if you are unable to make informed healthcare decisions. So you're not naming someone who can replace your decision making. You are adding people who can speak for you in a medical setting, and if technology has changed, you haven't limited them in this document, the standard document. Anything's available as a possible treatment, all right? You're just naming who can interact with doctors, what they say and what they do. Well, you're going to want to pick someone who's like-minded to you. You don't want to pick someone with very different belief structure. But whoever you've picked in this document can interact with doctors, nurses, hospitals, nursing homes, rehabilitation facilities, all kinds of places. And in this document, they can make any level of medical decision, including end-of-life decision-making. So, back to the interaction of living will and healthcare power of attorney, if you were squeamish about having a living will, then don't have one. Have a healthcare power of attorney. There's a box on page 5 of 12. It's at the top. It's called the special instructions paragraph. By initialing or putting an X or checking that box, you don't have to even make end-of-life decisions. You can just empower the person you name to do that for you. That's very, very useful. It'll help get a better decision. It'll more likely reflect your wishes. Best of all, it stays away from courts and lawyers. And you've improved your chances for the best possible result. Now, let's be blunt. None of these documents are going to eliminate death from occurring. If it happens, it happens. But you've allowed the process to take place in a dignified yet efficient way. And I think if you are having these preparation thoughts and you're having these discussions with people that you might name in here about how you feel, you're having a better chance of that person landing on a decision that respects your dignity but also is consistent with your wishes. That, to me, is a win, okay? Yes, ma'am, you have a question. Yes, that's right. So she makes the point of, just because you're, there's many, I think in summary you're saying there's a lot of ways that you might need this document that have nothing to do with death. I'll give you an even more common example. I have heard that when you go in for surgery, doctors in medicine uses anesthesia these days, and you might be under anesthesia. If you're under general anesthesia, legally you have lost the capacity to make an informed healthcare decision because you can't communicate with your medical provider while you're laying there under general anesthesia. Now, I had to have hand surgery about 5 or 6 years ago, general anesthesia. I was even more incompetent than I usually am. And I wanted my wife to be able to make decisions for me while in general anesthesia state. This document, Healthcare Power of Attorney, was the permission slip that allowed her to talk about even very boring, mundane, small things with the doctor. Now, also understand, in modern medicine, there's a huge emphasis on privacy, 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 privacy. Only you can know about you. People often ask me, well, they challenge me. They say, well, can't my spouse speak for me? No. No, this isn't Mayberry. In the real world, your spouse is a person who may or may not have consistent thoughts as you. So guess what? There's no automatic that a spouse can speak for their spouse. Really, the only automatic is a parent being able to speak for their minor child, and frankly, much of that has gone away. If you went down to Dayton Children's Hospital, there's a consent to treatment form that any patient over 12 has to sign themselves. So in the real world, privacy laws say that no one can speak for anyone else unless the patient gives consent. Now, truth be told, you can verbally give consent. So if I got dinged up in a car crash this afternoon and said, yeah, my friend Margie Christie can speak for me. She could, that's consent, but the problem with verbalizing it is you're relying on the medical provider to document that so that the next shift knows who they can talk to. A better solution would be have it in writing, and have it in writing before you would be in a medical situation, whether it's surgery or a car crash, like you said. Could be something planned, could be something unplanned. I think we all can appreciate there's a lot of medical conditions can come up unexpectedly, right? And better to have it in place beforehand. Now, in the standard state of Ohio healthcare power of attorney, a durable power of attorney doesn't have a shelf life other than your life. So a power of attorney that is durable is designed to last as long as you last. So if I signed a healthcare power of attorney in 2001, 20 years ago, a durable healthcare power of attorney is still legal and usable today. It's still legal and usable in 2041. If I died, powers of attorney of all types die with the power giver. There's no such thing as a power of attorney that lasts after death. But a durable power of attorney doesn't just go stale with the passage of time. Now, having said that, you can change them throughout your life, right? So if you did one in 2001 and 20 years pass and the people you've named have themselves passed away or moved away or you don't like them anymore, you can do a new one, and the new one replaces the old one, which brings up another point. I have a lot of people who say, oh, I'll just fill that out at the hospital, because they ask you, do you have that? Do you want that when you go in for surgery? Understand that each time you fill it out at the hospital, the words in here say that the later power of attorney replaces all prior powers of attorney, right? So if you wait to go to the hospital and you fill one out and then you don't take a copy with you, good luck using it the next time you go to the hospital. That's why it's important to keep a copy, have it available to you. Now, legally, you only ever need to use a copy, but I say you should always have this document handy, because each time you go to the hospital, you really should present it to confirm to the hospital, this is still my wish. So if I had been to Kettering Hospital 15 years ago for one hand surgery, and now I'm back there this year for a different one, I'm going to want to produce my healthcare power of attorney to the hospital so they know who I still want to be able to make decisions for me. Hopefully that made sense. People often ask, can I name more than one person as a decision maker? Legally, you can. You can have co. I really don't recommend it for very, very practical reasons. A couple of them are these. First, while you can name multiple decision makers, when you name multiple decision makers, understand that a hospital is really only going to feel confident that they have the decision, the consent of the involved people if all of them are there. So if you've got 3 kids and you name all 3, and one lives in San Antonio, one lives in Seattle, and one lives in Huber Heights, and you're in the hospital in Dayton, do you really think it's going to be that easy to get San Antonio and Seattle to get their instructions to a doctor? If you think that, get serious. I mean, if you've ever been to the hospital in the last 15 years, you have like 8 seconds with the doctor, and then they're moving on to the next patient. So availability is a problem. Second, what if they have disagreement? Now, legally in Ohio, it does talk about if there's disagreement, it's majority rule among powers of attorney, which if you only name 2, you never have majority rule if they disagree, because they cancel each other out, which means you have no decision maker, which means you're back into court because people aren't getting along, which means attorney, and that was the thing we're trying to avoid. So co is generally a bad idea. At my office, what we often do is we encourage people to name one decision maker at a time, but then we put a bunch of extra language in the document. In the box at the bottom of page 5, it's where they can add special instructions. We put a bunch of extra language in there that basically permits the giving of information. The privacy law issue, we waive it as to all named people regardless of the order that they are named. So if you had 4 of them and number 4 calls in, they could get information. Can't make decisions, but they can get information on their own. They don't have to call decision maker 1, 2, and 3 just to find out how you're doing. So that's a good tip. I already talked about you can live anywhere and be named in this document. Pardon? Yes, Margie reminds me that people often ask, so this is an Ohio healthcare directive. It's a good document. Most states have their own kind of model document. If you are a resident of Ohio, you're going to want to use the Ohio document. If you spend time in another state, let's say you spend 3 months in Florida, I say you should definitely have the Ohio document, but while you are in Florida, use the Florida document so that speed of recognition is there. So doing the Florida document would make sense because you might have some medical treatment in Florida. You don't want some unrecognizable document causing delay. So have Florida while you're in Florida, have Ohio while you're in Ohio. Now, a little tip, don't name different people because you're going to want to be consistent. If you name, oldest child in the Florida document and youngest child in the Ohio document, and they don't like what's going on, then youngest child's going to send Ohio document down to Florida and say, hey, I'm the decision maker, and then a fight ensues. And what happens when a fight ensues? More lawyer time, okay? So we don't want that. Powers of attorney and living wills are healthcare directives that are able to be signed by any adult person. Why is that important? Well, I told you a few minutes ago that parents of minor children are able to be decision makers for them, but if you've got children who are over 18 or over, if you've got grandchildren who are 18 or over, they are adults in the eyes of the law, and only an adult can make decisions for themselves. So a parent who sends their kid off to college and that child's over 18, that parent can't speak for their child's healthcare decision making, can't call up the doctor to see how they're doing, really can't make even emergency medical decisions. So this is a good document. These are good documents to have, especially the healthcare power of attorney, for anyone 18 and over. It really is. They are very useful. And again, you're not restricting what you're having the person do, meaning can consent to surgery but can't consent to, chemo. You're not being that detailed, and you shouldn't be that detailed. We want good, educated, empowered cooks, not restrictive cookbooks, okay? Which brings me, I think, to my last point on this. There are some people who they think they're being clearer by having a checklist, right? What I will call a matrix decision maker. If this, do this. If this, do this. Folks, you are not a Chevrolet. You are not an Apple computer. You are not a phone. So, you'll buy a new TV set and it says, if it doesn't come on, here's your troubleshoot. Is it plugged in? Is it on? Do you see a green light? Did you hit this button? That's great for a TV set or a car or a phone. That's not how medical decisions are really made. So and there are lawyers in this town who I'm friends with even, who they will encourage people to have these long page after page checklists. Do this, don't do that. I want this, I want that. I think it's foolish. I think it's foolish because it's pretending that technology is static. It's always going to be the same. It's not, okay? It's also pretending that all hospitals are the same. They're not. I mean, there are some country hospitals. You might as well go to a veterinary clinic, okay? And that's not making fun of the people that are there. They don't have any resources, all right? If you went to a farm hospital way up in Logan County that's got 2 beds, they're basically going to keep you alive until a hospital can get you to an ambulance can get you to a real hospital. That's why you see CareFlight fly up to these faraway hospitals to bring them to a real treatment facility. There's nothing embarrassing about that. It's a fact, okay? And if you had this matrix of if-then statements, there are some hospitals that can do wondrous things, like Mary pointed out, and there are other hospitals that can basically not kill you for a little short while. And that's why I think the matrix documents are a bad idea. There have been some proposals in the law over the years to basically make a matrix type document. A lot of times you see them called like the 5 wishes documents or the MOLST and POLST documents, which basically is medical orders for life-sustaining treatment or permanent orders for life-sustaining treatment. It's trying to make consistency. I get that. The problem is we live in a very quickly changing world. And so, to me, a better solution is name a more informed cook, not a more restrictive cookbook, right? So that's what these documents are doing, the standard documents. I said I had one final comment. I actually have another final comment. People will go in and try and alter these a whole bunch. I really don't encourage that either. These documents are produced through a large collaborative effort of the Ohio Bar Association, which is lawyers, the Ohio Medical Association, the Ohio Hospital Association, Hospice and Palliative Care Associations. They all come together. A lot of them are listed there at the bottom. And they talk about how do these documents work? Let's make that better. How do these documents fall short? Let's improve on that. So if you go in, you know, with your pen and start getting creative writing skills, I know it might feel good, but it's usually a bad idea, because what will happen is that document will get whisked away to the legal department of the hospital that you're in. So some lawyer, remember that's our goal, to avoid lawyers here, for all of us, that lawyer in that legal department is going to try and decipher, you know, what did John mean when he said, and it's scribbled on there, okay? So I encourage you to read the documents we gave you. They are widely available. The Ohio Bar Association, the various probate courts, Dayton Right to Life, lots of organizations push these documents out there to be freely available. Do them in anticipation of an emergency. You'll be doing yourself and your family and your people you care about a large service if you do that. Okay, I think that's it for me, right? Question time, okay?
Thank you, Jonathan. They like us to stand in front of the microphone. I got in trouble for wandering around, so we can't wander. Again, I can't emphasize enough how important it is to prepare. We do have this, I have extra of healthcare power attorney forms on the, in the back, and they're also on the Dayton Right to Life website, and they're all, like he said, approved by all these organizations. I know there's lots of other ones out there. Every Right to Life group in the country, I feel like, has its own little form that it uses. That just, again, slows things down. The legal department has to look at it. Just name someone who has your best interest, that you've talked with, that knows you, and you know them. It doesn't have to be the same person that does your financial health care or your power of attorney. We picked my first daughter. My first daughter is very organized, very, you know, she can speak for me. She's great. She's my health care power of attorney after my husband. Would I ever make her my financial one? No, she can't even find her checkbook most days. So you don't have to pick the same child. Know their gifts, know the person that you're picking. Would I pick daughter number 3 for this? No way, she'd be a mess. The girl cannot make a decision to save her life. So, I mean, Courtney's just not the one for that. So you know, and then visit with that person and talk with them. Again, probably not at Thanksgiving dinners, probably not a good time. Hey, you know, let's talk about me dying. So take time to do that and spend with. So I got a little, this is your homework assignment. So you're just going to pray, you're going to talk, you're going to find a healthcare power attorney, get your forms ready, and then do your research as things move along in life. And like I said, I sent all 4 of my kids off to college, and Jonathan yelled at me that I sent them without healthcare power of attorney form. You didn't yell, that's right, you did not yell. But just let me know that, you know, my daughter in Maryland was in a car accident. They never would have talked to me. I mean, I probably would have got there, but still, she was 18 in Maryland, and, you know, who knows the laws there. So, okay, if you have any cards you want to hold up or ask a question, whoever it's addressed to, we'll go from there. If you have a card or you just want to raise your hand, we're not a very big group, I'll grab your card.
Oh, yeah. I'll just read them out loud. If it's for me, I'll read mine.
Well, I think it's for the
Oh, for the speaker.
online.
Oh, great.
I'm not listening. Just make sure you talk to the microphone.
Well, one difference is the spelling, so that's the legal answer. Okay, so they'll come back to that one. Here's a couple questions. One of the questions basically says, let's say there's a married couple. Do both of the spouses each need to have a healthcare power of attorney? And the answer to that is yes, because it's individual to each patient. While it is possible to both be in the hospital at the same time, you should each have your own document, and you could name the same people, you could name different people. So many times, if I've got clients, like a husband and wife in to see me, the first decision maker is typically the spouse, but not always. We've got a lot of clients who one of the spouses is maybe in declining health, like dementia or something. We'll name someone not dementia spouse because that would be a bad decision maker. Doesn't mean they're a bad person, just means they may not be able to keep up with all the information that might be coming at them. So each of you should have a power of attorney. Okay? And then it says, another question is, can you name just one spokesperson, or should you name alternate agents? You can name just one. You don't have to have a bunch. But my general recommendation is name as many people as you're comfortable naming, because understand that the document could last a long time. So if the person you've named has health that is worse than your own, they may be unavailable just because they're too sick or they've moved away or some reason. So I say have as many backups as you're comfortable naming. Now, if you're making it a real stretch, you know, it's somebody whose decision making is very different than your own. Don't name them just to name them. Let's see, who should hold on to the healthcare power of attorney? Well, you should hang on to your own. At my office, we'll send the original with the client, and then we scan and email a digital copy for the client so they can print it off as many times as they want. Legally, you only need to produce a copy to a medical provider. Now, if you're comfortable circulating it to the people that you've named, you certainly can do so. Some people are hesitant to do that, and that's okay. I think it's important to at least tell the named agents where to, if you don't tell them the order, right? So if you had 3 kids and the oldest is kind of a goofball and you're like, oh, I really don't want them to know that they're 5th in the batting order, you should at least, it happens, should at least tell the people that you've named where to find the document if you don't physically put it into their hands. Yeah, so you can do, pretty savvy. You can have electronic copy. We scan and email them out. We emailed you yours.
Yeah.
Okay. Go ahead.
I think personally that it's a good idea to tell the persons who are going to be your spokespeople that they're it. And it's probably not a bad idea to tell the other kids that they're not it, in a nice way. Don't you think? I mean, because it's going to I don't even like to say this word in church. All hell's going to break loose if you don't. I have seen that happen so many times in the most in the middle of an intensive care unit. We've got World War III going on because
Well,
nobody
it's
can
a
answer.
stressful time. And when it's stressful, emotions tend to run hot. And when emotions run hot, people tend to say things that is not really well thought through. And so then feelings get hurt, and then we fail. More lawyer time, right? So we don't want that. Two more questions. I think they're both pretty easy ones real quick. It says, can you have copies of your power of attorney for each time you go to the hospital? Yes, you can, and that's exactly how you should treat them. Take them each time. And then it makes reference to what if a patient has, like my chart, so Kettering and Premier both use my chart. Would it be a good idea to upload your power of attorney to there? So you can, you still need to take it with you each time, okay? So let's say I had done a healthcare power of attorney in 2001 that named my brother. And then 2 years later, I got married, and my new healthcare power of attorney names my wife, and then my brother. Well, if the document that names brother is still in my chart, that's believed to be my current wish. So if I take it and produce the one that names my spouse, it replaces the prior, and it's more accurate to my current wishes. So does that make sense? Okay. And then I think this man, oh, hey, we lucked into covering a question before it was asked. Yes, ma'am. That's a great question. So the question was, what if you have a healthcare power of attorney and you want to change it? Should you go through a lawyer? Well, you certainly can. A lawyer, I would encourage using a lawyer who does estate planning work versus a lawyer who does, say, bankruptcy or personal injury. I mean, a personal injury lawyer is probably motivated for you to get a bad result, okay? No, I'm kidding. That's a joke. In truth, these documents are very straightforward. So if you had a document that you knew what you wanted to change, you should be able to download it, for instance, off Dayton Right to Life's website, print it off new, and the way it's written, the pre-printed language says, the later document supersedes all priors. So if you had one that was dated November the 7th of 2001, and your new one's dated November 7th of 2021, it's replaced all of them, and it should be super simple to fill it out by yourself. Now, legally, they have to be signed and either witnessed by two people or notarized, not both. Most lawyers are going to notarize it only. That's what we do at our office. There are rules on who can be the witness. So a person you name in the document can't be one of the witnesses. If I wanted to name Margie as my decision maker, she can't be a witness to that document. If you name your spouse, the spouse can't be a witness to the document. And so that you just need to be careful on the witnessing part, that you follow the rules, okay? But yeah, it's straightforward enough that you should be able to do it on your own. And I don't mean this about you. This triggers another commonly asked question. People will often say, oh, what if I had named my spouse, but that person is now no longer my spouse? Understand that in Ohio, state law says that the filing of a divorce or dissolution or an annulment automatically cancels out the spouse, just not even a finding of divorce, dissolution, or annulment, the filing of it, okay? So I had a case one time where this really crummy lady, it was a lady in that case, she was awful, and she went and emptied out all the bank accounts, moved the house into her own name, and then she promptly loaded her aged husband into the car, drove him 4 towns away, put him in a nursing home, plunked down cash for 1 month, and then said, don't call, don't write, and then she filed him for divorce 2 days later, okay? Yeah, I've seen that. I could tell you guys stories all day long that'll make your skin crawl. But in that case, the guy's kids, who were not her kids, they were very concerned that she had made a bunch of medical orders that would basically shorten his life. This is their dad. And I said, here's this law that says the filing of the divorce cancels out anything that that woman has said or done, give it to the nursing home, and they will scratch out, everything that she had consented to. And it did, actually. She had put a whole bunch of pretty terrible things in place that he would have next to no care. So they started listening to the sons because we got a healthcare power of attorney signed, and that law canceled her out. But crazy, right? So it's easy to do a new one. You can just do it. Keep a good record. Get rid of anything old. Yes, ma'am. For health care, if you're going to use the standard healthcare power of attorney, it is designed to be DIY, do it yourself. That's right. Yep. Now, if you sign it and you don't have it witnessed or notarized, yeah. Are you a client of my office? No, I'll say this. So, like at my office, people ask, how much do these things cost? At my office, we really don't charge for the healthcare powers of attorney. We charge for financial powers of attorney, and we recommend these documents. And so we just do like a package deal. Hey, for all of those types, it's $150 for all of it. Now, if a person says, well, I don't want the healthcare. Okay, it's $150 for the financial. Okay, so that's kind of how it works at my office.
Can I tell them my story?
Yeah, go ahead.
So real quick, my sister and I and my brother went to Jonathan when my brother got the esophageal cancer, and we named my sister the healthcare power of attorney for him. And Jonathan got all the paperwork together. And so interesting enough, I mean, we really weren't paying attention because, you're dealing with all that kind of stuff. But so it came to my brother passing away, and we go to Root Song, and he was going to be cremated. And Root Song says, are there any other living relatives besides you and your sisters? And I'm like, well, he had a daughter. He had had a daughter when he was 17 years old. He never took care of her. She ended up being adopted by someone else. And he said, we cannot cremate your brother until all living relatives have signed off on it. And I called Jonathan. I'm like, I don't even know where this girl is. We haven't talked to her in 30 years. I'm like, Jonathan, he's like, Margie, in your paperwork, look through your papers, and there's a form there that also, when it named Chris the healthcare power of attorney, it was another form that also put her in charge of all his burial things. So we did not have to try to track this girl down, and he was able to be cremated like he wanted to. But thank goodness that. It's not a personal plug commercial for Jonathan, but honestly, we were just taken aback. We had no idea that was a thing.
Okay, sales pitch time. So, as much as I don't like lawyers, the truth is, I look at my practice, I'm a mechanic, all right? And if it's an oil change that you need, then I'm going to give you an oil change, the best one I can do. But if an oil change isn't going to fix your car and you need a new transmission, well, then I know how to do that too, right? And so this type of document that Margie's talking about, clients come in all the time and they'll say, I want, the list of documents that take care of everything. Well, you're talking about a last will and testament, a financial power of attorney, a healthcare power of attorney, a living will, a burial declaration, possibly some deed work, either a survivorship deed or a transfer on death designation. I just rattled off in quick succession 7 things that are super duper common. I write hundreds of them a year. That's not bragging, but the point is, I know what I'm doing. If you ask me to cook a souffle, I might be able to cook a souffle. I can eat, obviously, but I think that if you ask me to cook a souffle, it's a lower chance of success here, right? If you ask me to change an actual transmission, I have no chance at doing that. So what is an estate planning lawyer doing? They are able to not only identify the simple solutions that you may have done for yourself, but to make sure it's done right, but also a whole bunch of other stuff that could help you a lot of different ways, okay? So as much as I've minimized the legal profession, a lawyer who knows what they're doing can give you a great deal of help and eliminate a great deal of stress. So Ohio does recognize a burial declaration, and cremation can only occur if a majority of next of kin sign off on that. Because remember, cremation is Once done, cannot be undone, all right? It's a permanent thing. So by law, it has to have all these people sign off on it. It's a fact that families are pretty spread out, and families don't always get along. I have had cases where this poor woman, I think she laid on ice at a nursing home for 3 months. 3 months, while one son argued with his brother about who was going to get the car, and he wouldn't sign over mom getting cremated until he had the title in his name, and it was gross. And again, I could tell you stories that'll make your skin crawl. But there's lots and lots and lots of documents out there that are very helpful. This just happens to be a real easy lift that you can even do yourself. Good?
So he had the question on the medical care versus medical treatment.
Oh, yes, medical care versus medical treatment.
In my mind, we're kind of talking about,
Well, repeat the question first.
what is the question? Oh, the question is, what's the difference between medical care and medical treatment? Now, I'm just going to say this from my mind, and you can add your 2 cents here. In my mind, it's not that different. We kind of interchangeably talk about treatment proposed and care given. But I don't know what that means. It's pretty much on the same scale. But say what you just said before.
Sometimes what happens, though, is what a hospital or a doctor refers to as medical care is maybe not the Catholic version, maybe, or Christian version of what we would say is medical care, including the nutrition and hydration. Dayton Right to Life, along with Cincinnati Right to Life and Bobby Schindler, Terry Schiavo's brother, and the Archdiocese are in the process of drafting a piece of legislation that actually makes nutrition and hydration medical treatment. Or, basic care, not medical treatment, that can be removed. Right now, it's a medical treatment. Right now, food and water is a medical treatment that can be withdrawn.
Oh, I see where you're going.
Yeah, so that was the thing with that.
One of the things that I think since we're here at St. Chris, as Catholics, we need to realize, and I'm saying this as a person who worked at Good Samaritan Hospital for a long time, when Good Samaritan Hospital closed, we do not have a Catholic hospital in Dayton, Ohio. We have St. Leonard's, which is a retirement community. We have Mercy Siena, which is a retirement home. But we do not have a Catholic hospital here. When we worked off of at Good Sam, we used the medical directives for Catholic health care, and that was our document. So when anything would come up, like someone was having a hysterectomy, they've had 5 children, and they want their tubes tied because I'm open, my belt. Well, I have to always, because surgically your abdomen is open. We could not. That was not that's not something we just did because it's convenient. That would have to be rescheduled. We would do everything in our power with a physician to have them deliver at Miami Valley or wherever. But when St. E's closed, and then Good Sam closed, there is none. I'm not saying, though, because I worked for Premier at the end, I'm not saying that they were really doing unethical things in those institutions. But the consideration was always a little bit more deliberate in the Catholic healthcare setting, because we use the medical directives for healthcare. Is that a good answer? Okay.
Okay, that is what we have for today. Oh, one more, Mark? Yeah. That's right.
You talked a little bit about this checklist type document, not necessarily good. Is the Living World Declaration an example of that? Yeah, so basically the question, as I'm hearing you understand it, is carrying out my discussion about, or my comments about not using a checklist, is the concern, or the question has to do with, is the living will an example of a checklist document? And the answer is, typical lawyer answer, it depends, okay? It is much closer to a checklist document than the healthcare power of attorney. So if you have any hesitation about getting anywhere close to something that is like a checklist document. You have to understand that the living will is the closest of the standard documents to that, about what will happen, what won't happen. And if there's a page in your materials there that has the triangle on it, when you have the living will in those two circumstances, terminal condition or permanent unconscious state, it trumps everything else and is the highest, most commanding document. So if you are concerned and if you are not completely comfortable with what the living will is saying, my comment would be, then don't have one. It's the easiest document to opt out of it and just have the healthcare power of attorney. And if you do that route, it's not a checklist. Going to page 5 of the healthcare power of attorney, if you initial the provision that's in bold that says, I specifically authorize my agent to refuse, or if treatment has started, to withdraw consent to life-sustaining, it says artificially or technologically supplied nutrition or hydration. Understand, you're not doing a checklist with that. You're empowering the decision maker for even end-of-life decision making. So a very simple alternative to having a living will is have the healthcare power of attorney and make sure you've checked that box, because that way, whatever's going to happen to you, it has to run through the decision maker collaborating with the doctors, what I call two-party decision making. Decision maker plus doctors together. Now, some people are very hesitant. They'll say, oh my gosh, it says withdrawal of artificial nutrition and hydration. That sounds like something that I am philosophically and opposed to it. I don't think that's the proper reading of that paragraph in the healthcare power of attorney, because understand, if you leave the box blank, you don't have two-party decision-making where it's your spokesperson collaborating with doctors. You actually have three-party decision-making, which is the people you've named in the document, the doctors, that's the same, and then you are automatically into the jurisdiction of the probate court being the third decision-maker, basically to say, here's what's going to happen for end-of-life treatment. So this is not saying you want to hasten death or not have things done to you, a checklist. Instead, it's saying, I am okay with two-party decision-making that doesn't involve the court versus three-party decision-making that will involve the court. That's all that paragraph is saying. Okay? So living will, close to checklist. If you're hesitant, don't have the living will. But I do recommend having that box on page 5 initialed regardless of what you decide. Great question. So the question is, let's say you already have a living will, and I'm just going to make up a fact. Let's say you signed a living will in 2005, and then you do a new healthcare power of attorney in 2021. The healthcare power of attorney will not replace the prior living will. So if you have a living will and you want to revoke it, you should have a written statement that says, I revoke my living will, for instance, in my example, from January 1 of 2005. That's right, that's right. I suppose, and I would probably do it this way, I would have a written statement that says that, and I'd also put in the special instructions, this document specifically replaces and supersedes and revokes prior living will, in that page 5 of special instructions. But that's a great question, because you're starting to see how they interact with each other, right? And they are different documents. Good?
Yep. I just have one point of clarification before on my story. I wasn't picking on my oldest. I put my oldest on that form because my husband and I travel so much, and so it was recommended that if we're in a car accident together, right, we still need that other person. For when you are listing persons, you might want to put someone else beside your spouse with whom you travel a lot, or whoever you travel with a lot, just in case, so there is another person that can speak for you. And actually, my husband picked somebody else. Well, we'll talk later. But
I wish all people I dealt with were as good
I
a listener as
listened,
Mark.
I did listen. All right, you have two great resources here. We got some resources back on the back table. This is a great book. It's called We Are the Lord's. I don't have any extra copies, but you're welcome to take a picture of it and order it on the Catholic Company or some. It's a great book. And then this one covers every life issues, medical choices from beginning of life to will you help me die, to the ends of life, all kinds of different medical questions. So this is just end of life, and then this is all life decisions, so healthcare. So
Very broad distribution for this presentation today. A lot of churches, Margie's distribution list in the Cincinnati Archdiocese Respect Life distribution list, but there's a lot of people aren't here. So this is for you, but it's also for your kids, and even myself. I'm thinking I have some kids who went out of the country while I took care of their kids, but they should have had health care power of attorney while they're out of town or plane crash, and with not just their health care or whatever happens, but who takes care of the kids, something like that. So it's your kids. Yeah, but it's for your kids, for your loved ones, your parents, a family friend, or if you just know a neighbor who's got cancer, hey, you might want to think about this. This presentation is being recorded, and we'll get the information to you if you want to see it again. I guess that's it. Thank you for coming.
Yeah, no, this is for this place. Elena gave